offer is to dismiss those.
You don't have to. I'll defend myself against them. Please call the other cops in.
No, I'm not.
I'll take on all of them.
No.
Make sure he's there.
Mr. Hicks.
I see him in the neighborhood anyway.
Your Honor.
Mr. Hicks.
So you can't punish me for any of this.
This case is one of those rare moments in court where you can practically watch a good deal get up, walk away, and vanish in real time. From the very beginning, you'll notice something important. The judge is patient, the prosecutor is reasonable, and the court is actually leaning toward leniency. Tickets are lined up to be dismissed. Fines drastically reduced. No jail. No points. All the pressure is off if the defendant simply accepts it. But instead, we're about to witness a classic sovereign citizen spiral. The kind where someone confidently quotes court cases they don't understand, challenges charges nobody is even pressing anymore, and slowly talks themselves into a much worse situation. The key players here are Mr. Hicks, who insists he travels instead of drives, and a very composed judge trying to walk him step by step through reality. What starts as a routine appearance turns into an argument about contracts, the Constitution, and imaginary loopholes that somehow always seem to vanish when an actual judge is present.
Versus Albert Heimer Hicks. Names for the record, attorney first.
Hey, police court, Harry Boffin on behalf of the defendant. Sir, would you state your name for the record?
Albert Heimer Hicks, Jr.
Thank you. Good morning.
The defendant
informed
that he does not wish to be represented by counsel this morning. I will remain in a potential advisory capacity just in case.
Okay. Is that correct, Mr. Hicks?
Yes, that's correct.
Okay. You know that, so let me see what's happening here. I see an offer that ends up dismissing a lot of matters. I can't be your lawyer, so I'll just tell you what's here. And Corporal Spidell is here. See what I'm just trying to make sure I understand the offer. So you have 8 open matters, and there is a recommendation to dismiss 6 of those matters in return for a plea on 2 of the matters, and both matters are being reduced to driving with improper plates. I think, it was driving unregistered motor vehicle reduced to driving with improper plates. Oh, I'm sorry. And the other one is being reduced to, I don't get this other one, Ms. Jansen. Is it being reduced to failure to report accident under MCL 257.621?
Yes, that's correct. That's a 0-point offense that doesn't abstract, and it's a maximum of $100 for a fine.
Oh, okay. So the false insurance information ticket would be reduced to failure to report accident, which has a $100 fine cap and does not abstract for, according to the prosecutor, for insurance purposes. And then the other one would be to reduce the driving an unregistered motor vehicle to improper plates. And then the other 6 matters would be
Here's where the tension really begins. The judge isn't just explaining the offer. She's practically gift wrapping it. Reduced charges, minimal fines, no lasting damage to his record. But instead of recognizing the lifeline he's been handed, Hicks is already preparing to argue. This is a defining sovereign citizen pattern. The belief that rejecting ordinary legal processes somehow puts them above the system, when in reality it usually places them directly in the path of harsher consequences. Notice how the judge speaks calmly and clearly. She isn't antagonistic. She's cautious. She's seen this before, and she already knows where it's likely headed. The only real mystery is how far Hicks is willing to push it, and how much damage he's willing to do to his own case simply.
Mr. Hicks, would you like to avail yourself of that offer? That takes something that was a $500 fine as the maximum to a $100 fine as a maximum with no points.
I never had a license. I never acquired a license. I have no contract with any company.
This has nothing to do with a license. So those license matters. The offer is to dismiss those.
You don't have to.
Okay. You want to go through all of these tickets then?
Let's run.
Okay, so let me just say, Mr. Hicks, if you're making a motion for, I'm not sure what you're doing. You
I'm
sure you
making
don't
a
want to have, let me just
mistrial.
ask.
I'm making a motion for a mistrial for the simple fact the officer did not have cause of action on private property. As far as the license is concerned, I'm going to rely on the decision from the Supreme Court and constitutional defenses.
Well, can you tell what those are so that the prosecutor can
Of course.
say what she's
I
saying?
travel with the common law. I have the right to travel. Shapiro versus Thompson states that. Murdoch versus Pennsylvania states no state shall convert a secured liberty into a privilege. Y'all are calling driving a privilege or traveling a privilege. It is not a privilege. It is a liberty. Shuttlesworth versus Birmingham says I can ignore the license and engage with the right with impunity. So you can't punish.
Sarcastic jab you just heard captures the energy perfectly. This isn't new territory. Courts across the country see waves of defendants convinced they've discovered secret interpretations of the law that somehow overturn decades of legal precedent. But watch carefully. Hicks isn't just rejecting the deal. He genuinely believes is about to win outright. That confidence doesn't come from the facts of his case. It comes from online echo chambers and half-understood legal language. And that's exactly why the judge keeps slowing down, clarifying, and trying to ensure Hicks understands the risk. Every time he doubles down, he's not hurting the court. He's hurting himself.
Thank you.
I'm going total constitution on everything. This is a court of law and not equity. So all those civil infractions, y'all can wrap that up because nothing was injured. No one was injured and nothing was tore up.
Just so you know, Mr. Hicks, there are no civil infractions up today.
Those have to be civil infractions if you're trying to charge me money.
I'm just saying, you mentioned civil infractions, and I just want to make sure that you understand that these are all misdemeanor offenses against you. I'll go through them. Let me tell you what's up.
I already have them right here in front of me.
Well, I'm trying to do my due diligence, Mr. Hicks. Driving while license suspended, driving an unregistered motor vehicle, driving without insurance. Those are the 3 counts. Also pending is the driving while license expired. Count 1 is failure to display a valid operator's license, not on person. Count 2, driving unregistered or untitled motor vehicle. Count 3, driving with improper plates. And then the last one I have, the charge is providing false or fraudulent insurance information.
That will have to be proven.
Okay. Those are what they're scheduled for a bench trial before the court right now. And what I was trying to explain to you is that there's an offer that's been made by the prosecutor.
I understand.
Hold on 1 second. I'm already dismissing 4 of the matters because the officer has not appeared. Okay. So the prosecution couldn't go forward. So those are being dismissed without prejudice. And those would be counts 1, 2, and 3 of SP 1335615. I assume Officer Reed is not present. And that was scheduled for trial. I'm dismissing those, okay? The driver's license expired, case number SP 1218560. I'm dismissing that count 1 that's up as the officer Hernandez has not appeared, okay?
I wonder why.
Don't worry, a lot of people, that happens sometimes. Well, let me just say, let me just say, they may have been here before. I don't know, because some of these you haven't appeared for. So I don't know if the offer would change. So the only matters that are pending now, the other matters are gone, that were scheduled for today, would be the fraudulent false insurance information, SP 1055542, 5 5 4 2, and SP 1055540, failure to display an operator's license, driving an unregistered motor vehicle, and driving with improper plates. Those three. Right now, and I don't know if the offer would change because some of the matters are gone. But right now, with those matters here, the only plea offer that's being made would be to failure to report an accident, which has maximum sentence of a $100 fine.
What
And that-
accident?
No, so just so that you know, Mr. Hicks, what the prosecutor does a lot of times is that in an attempt to resolve a matter, they'll have you plead, but they'll ask the court to accept the plea to a lesser offense that doesn't.
I understand that doesn't hold as much weight as
that doesn't affect you as bad.
I understand it, but by the way that I live now, as a researcher, don't need it. I do everything constitutionally. I don't follow laws or codes. I follow
well then that's what this is about. These are laws or codes.
Those are not laws, those are codes.
Okay, so if you
they are not laws. The Constitution, it holds no weight with the Constitution nor the Supreme Court. And I'm willing to take it all the way to
Your
the Supreme
Honor,
Mr. Hicks, just hold on, please. I'm just trying to get.
Because it seems like you're trying to talk me into something.
I'm not trying to. Absolutely not. That is.
This is the peak of the right to travel argument, and it's important to recognize what's actually happening. He is mixing legitimate constitutional language with totally unrelated traffic law, then drawing conclusions that simply don't exist in real courts. No one here is arguing against his freedom to travel. What's actually at issue are vehicle registration, plates, and insurance, responsibilities that come with operating a motor vehicle on public roads. But instead of addressing the actual charges, Hicks is delivering a lecture he likely rehearsed long before he ever walked into court. The problem is that courtroom outcomes aren't determined by speeches, they are determined by applicable law. And the more he insists these basic regulations don't apply to him, the more he backs himself into a corner.
Mr. Hicks?
From the Department of Transportation.
Mr. Hicks?
I have nothing to do with them, never had a contract with them.
Okay, Mr. Hicks. I'm not trying to talk you into anything. I just want you not to come back and say that I didn't explain something to you. And I am not your lawyer. I'm the judge. So I just want to make sure, though, that you don't come back with something else. And I just wanted to let you know, because you didn't talk to the attorney, what was being offered. That's all. And you made your argument. I'm going to have the prosecutor make an argument, but I've already gotten rid of some of these, okay, for other reasons. And so I just want you to know that at least with respect to the offer that was made before, and it may have changed, these other three matters would be dismissed, I think. Yes, these other three matters would be dismissed. The failure to display, the driving unregistered, and driving with improper plate. But that's only if you plead.
I will not plead. I refuse.
Okay, all right. No problem then, Mr. Hicks. I'm just telling you what that offer is from the prosecutor.
I understand.
It has nothing.
I understand. I'm 57 years old. I speak English well, and I translate it real well. I even have you on caption. I'm reading everything that you're saying.
Okay, all right. That's good. I just want to make sure there's no issue. Attorney Jansen, what about so we have 4 matters that are pending. Corporal Spidell is here, and he's here on those 4 matters.
Yes.
Okay.
Your Honor, go ahead.
Go ahead. So Mr. Hicks has made a motion before we move forward with the trial.
Your Honor, I guess I would like to speak with Corporal Spidell about these cases. But prior to that, I just wanted to clarify that the defendant has submitted to jurisdiction.
Thank you.
Thank you. I have had the chance to speak with Corporal Spidell, who was the ticketing officer on this case.
Okay.
We are requesting an in-person trial date.
Beautiful.
So just for the record, all we have left are the 4 misdemeanors that I indicated.
Yes, Your Honor.
Okay, all right. But I need you to be ready to respond to Mr. Hicks's motion. He just made an oral motion. I don't know if you want to do that now or do that at the time.
I can do that at the time. If he could actually reiterate his motion in writing, that would be
Can you put
helpful.
that motion in writing, Mr. Hicks? And you would have to give it to the prosecutor, Attorney Jansen.
Well, the thing is, when I was reciting it, no one was taking record of it.
We
So
have
that-
record. We have a record of it, Mr. Hicks.
So
I mean,
she-
we have a record of everything. No. Let me tell you, Mr. Hicks, a lot of times written motions are required. And usually, if that happens, then written responses are required.
okay, beautiful.
I'm just trying to,
Where would I bring or send these motions?
you can file it with the court and with a copy to Attorney Jansen.
You will have to send me that information because I have nothing to jot with at this moment.
Notice how the judge methodically lists every remaining charge. She's not arguing with him. She's putting the reality of the case on the record, so there's zero confusion moving forward. This is critical, because defendants who represent themselves often later claim they weren't informed or didn't understand. By spelling out each count, suspended license, improper plates, fraudulent insurance information, she's creating clarity and protecting the integrity of the process. Meanwhile, Hicks continues focusing on abstract constitutional ideas instead of the specific facts of his case. In court, details matter. And right now, the details are not on his side.
Add it to you. But the filing with the court is different. You should already know how to, there's nothing special about that. Okay? And give me 1 second, I'm gonna try to get a date. So that means you would come down to court.
Well, I wanted to do it in the first
Yeah.
place.
Okay,
For,
all right. It's still scheduled for a bench trial.
Beautiful. For a bench trial.
So I can schedule this for adjourn this bench trial until March 27
Hold on.
in person, 9 a.m. Is right now it's scheduled for a bench trial. And so that's what we would have been going forward, but we'll move it then in person. So make sure that you come in if you have any witnesses or other evidence, make sure they're present. And if there's any motion to be heard prior to the bench trial, we'll do that.
I said everything I had to.
Do you have that, Ms. Jansen?
I asked for a mistrial.
Yes, I've
Yes.
emailed Corporal Spidell with that date, March 27
Okay.
at 9 a.m. Thank you so much.
Our schedule. Hopefully we can get started
Judge
close to that
Miles.
time. Yes,
Judge,
Mr. Hicks.
are they going to have me just sitting around like I'm doing today? Because I do have a business that I run, and I will be asking for. Why
For
not?
sitting around, because that's not anything that's allowable.
Oh, it's not.
No, it's not.
Law.
It's not allowable. It's not allowable because the court has to do its business for everybody. Okay?
Even when I win this, I'm not allowed my cost and fees.
We're not going to talk about that. You were talking about sitting around and waiting. So you're not.
I mean,
You're not.
like a game to try to pressure me out. But
No, Mr. Hicks. So Mr. Hicks, just like I'm not imposing any costs and fees on you when you missed your court dates. You missed court dates earlier. And you've been doing that. I see it.
I walked in the same day down at 36th District and
So
rescheduled.
Mr. Hicks, I already made my decision now. Come on. I made my decision. You asked me and I said I wouldn't be able
Please
to
don't
do
try the intimidation thing.
This is one of the most revealing moments in the entire hearing. Hicks genuinely believes the judge is trying to manipulate him, when in reality she's doing the opposite. She's stepping back and letting him choose his path. Judges cannot force defendants to accept plea offers, even very generous ones. What they can do is make sure the defendant understands the consequences of rejecting them. Right now, Hicks is mistaking explanation for persuasion and independence for legal strength. The sad irony is that he came into court with multiple tickets already on the chopping block, and through sheer refusal to listen, he is slowly resurrecting every problem the system was ready to let go.
You can only, let me, just, Mr. Hicks, I'm gonna talk to you, Mr. Hicks, just,
Yeah.
can you listen to me for a second? You can only be intimidated. No, yeah, you can only be intimidated if you feel insecure. So if you feel insecure, that's where that
No,
comes
it's
from.
not feeling
So
insecure.
nobody's trying to do that. Mr. Hicks, can I just say,
We'll see. We'll see.
but Mr. Hicks, can I just say that you've been given every, I don't even want to say, we've been, because we've been following the law, you've had cases dismissed because that's what we're doing. Because of it. Not in spite of it. Okay? So I hope it's fine that that's happened. So we're down to 4 matters, and it sounds like you have no problem with coming in.
I
Correct?
still would like a jury trial. I would love
Pardon?
a jury trial.
You're wanting a jury trial?
Yes, that's what I asked for in the first place.
You asked for a jury trial at some point and didn't appear. And so it went into show cause
And
status.
that was done.
You
did-
did?
Thing inside of what's that little township? Every time I ask for a jury trial, no one wants me to come in and speak my law, speak the Constitution in front of people.
Wait a minute. So you didn't, I mean, I'm just saying, you didn't appear several times. I'm looking here. So let me just say, if you want a jury trial, I have to give you another date. I didn't know that. So because because the last time you were,
filed, I have a paper here that says I would like a jury trial.
okay, Mr. Hicks, I scheduled a jury trial for you. It looks like a couple of times, and you did not appear. So,
Yes, I did.
Okay, but let me just say, we were ready. Okay, Mr. Hicks, you want to get some counsel for that? Because it really takes a lot. I can't be your lawyer. We have to choose a jury. There's a lot of things that happen. And if you don't believe in the law to begin with, let me do this. I don't
color of law. I believe in the Constitution, the supreme law.
Mr. Hicks, you can put your motion in writing. Ms. Jansen, you respond to it, and we'll schedule that for a hearing date. Then you don't have to come in. And then we'll see if this moves forward. If this is moving forward for a jury trial, I have to give you a jury trial date. That's completely different from a bench trial date. Okay? Like our scheduling is different.
I'm getting the fees out of this.